You just speak a word into the mic.
How are you, Stan?
Right.
Okay.
Very good. Okay, now you can, anything you want now, Tom, or what you were just speaking about, and then any of these other points that you want to get in.
Well, there's just that one further point on
yeah.
Castengate. Now, there was one question that I would have dearly wanted to ask Castengate, but unfortunately I had reason to believe that the answer would not have helped my cause one whit. And that was whether or not to bring out the point that Castengate had ever in the past given other workers on construction jobs rides or lifts on this forklift truck or a similar apparatus. We had reason to believe that his answer would have been in the affirmative, that he had seen it done on some occasions and that on some jobs he had done it himself in the past. Therefore, I refrained from bringing that out and wondered whether or not Attorney Locke would do so. However, Mr. Locke was probably just as fearful as I was of asking that $64 question because, admittedly, he didn't know what the answer would be, and it's a cardinal rule not to ask a key question of that sort unless you know what the answer is going to be, because it's either going to hurt you or help you. And as luck would have it, Larry never did ask the question. After the case was concluded, we chided each other about that particular question that each of us had in mind without asking. And Larry admitted that he was afraid to ask it for fear that Castengate might come out in so many words and say, well, he had never done it before, he had never seen it done, which of course would have helped my defense by some measure. And I knew that had I asked him whether he had ever given men rides or lifts up on these forklifts before, and the answer would have been, if the answer would have been yes, it would have hurt my defense immeasurably. So it remained an unanswered question, and it didn't hurt or help anybody. So
Really an unasked question.
An unasked, I'm sorry. It remained an unasked question, and therefore no one was hurt or helped.
Very good. Now I have here, you might comment here on having asked further questions about any conversations. Yeah, now, I don't know whether we want to put this in, Tom, but you did ask, presumably in response to cross-examination, you repeated your questions. I don't think we need this, though, unless you want to mention it.
What?
That you asked him again about the terrain and whether it was dangerous, and he repeated that he thought it was.
I think that's in there enough, don't you?
Okay, I think we can.
Either way, according to your statement or my earlier way of putting it over, I
Yeah.
think we covered it pretty
Yeah.
well.
Well, I think we can go to Unit 4. Clarence Patton, instead of a quote, will handle his testimony in the form of a summary. Patton testifies that he has never authorized any man working under him to ride in a forklift tub. He testifies that he has never seen personnel riding or being hoisted. He testifies that Mr. Sal never requested permission to ride. He testified the Fang probably weighed about 150 pounds. So that's all we have to get in the summary of your direct of Patton.
Do you want me to just cover where
Yeah,
it says Patton testified that he had never...
your recollection of it,
Yeah.
as best you can, of what happened with Patton on the stand.
The next witness called by the insurer was Clarence Patton, the employer in this case. His testimony was rather brief and substantially as follows. He testified that he had never authorized any of the men working under and for him to ride on any of these forklift trucks, that he had never seen any personnel riding the tines or forks of these trucks or being hoisted to levels above the ground. And he further testified that Acero had never, in any of the occasions when he had worked for Patton before, requested permission to ride on the forks of a forklift truck. And inasmuch as there had been some discrepancy concerning the weight of these two tanks, further questioning was directed to him along these lines, and it was his best estimate that the tank probably weighed in the vicinity of 150 pounds. So actually, the only positive information obtained from the employer, Clarence Patton, was of a negative variety, in that he had never seen this particular thing done before on any of the jobs that he had been working on or had observed, that Asaro himself had never had occasion to his knowledge to do this before, had never requested permission to be hoisted up on the tines of a forklift truck. In other words, to bring out that this was something certainly most unusual and further our defense in that respect. And there was no change in his testimony on cross-examination.
We can now go to Leslie Pratt, Tom.
The third witness called by the insurer in its defense was one Leslie Pratt, who at that time at least was supervisor in the Division of Industrial Safety in the State Department of Labor and Industries. And he appeared in response to a summons by the insurer. He was asked whether or not his department promulgated rules and regulations pertaining to the prevention of accidents on construction jobs, and he replied in the affirmative, stating that there are such rules which appear in Industrial Bulletin number 12, with particular reference made to sections 179, 180, and 181 of said bulletin, which was then, or a copy of which was then admitted in evidence. And quoting from sections 175 through 181, he had reference in his testimony to the various lifts and hoists which are used on many construction jobs and which are characterized as lifts. And then in answer to a direct question as to how a forklift truck, such as was used in this case, would be classified, he replied that such a forklift truck would come under the general heading of a lift or a hoist. And that further, these are material hoists. They are not employed, nor are they intended to be used in lifting workers above the ground or in general transporting them about as, say, a Jeep or other mechanized unit would be used.
I don't know why I left it out, Tom, but I noticed looking this over that there's no reference here to Gustenheiner, who was a dealer in forklifts and a dealer in this type of forklift, although he had never sold this particular piece of equipment.
You want me to cover that briefly?
I'm wondering if we might cover it. Maybe while you're looking
All right.
for it, I'll turn the machine off.
Was it Walter? I don't have his
right.
first name here.
It's all yours, Tom.
Next, the insurer called one Walter Geisenheiner, who identified himself as Vice President of Brody Industrial Trucks Incorporated of Malden, Mass., dealers of heavy equipment including forklift trucks manufactured by the Clark Equipment Company of Michigan, manufacturers of the Ross forklift truck in question. The witness described his engagement in his present capacity since 1947. His work involved the selling of such equipment as described previously, and included therein is the distribution of literature, safety films, etc., concerning the operation of such equipment. He declared that these various brochures and safety films contain suggestions as to the do's and don'ts, one of which is that personnel not ride on the forks of forklift trucks. On examination, he agreed that although such information as contained in these various training films and literature accompanying the sale and purchase of this heavy equipment is not always relayed to the purchasers of said equipment, it is always theirs for the asking. Of course, he had no knowledge whatsoever of the piece of equipment in question, and certainly no knowledge of what transpired on the day of the accident. But once again, it was the insurer's purpose in calling him as an expert in that particular field to establish that the sellers, the manufacturers and sellers of such equipment obviously are aware of the potential danger in the use of such equipment as personnel carriers, so that they see fit to print literature, have training films pointing out the dangers of the use of such equipment if not properly used.
I think we're done now, except for the summary of the brief. And I've written a summary here, Tom, for your use if you wish to follow it.
Oh.
In other words, you're now addressing
Yeah.
yourself to the commissioner, and you're trying to summarize
Well,
for
this,
him.
we didn't argue this orally, you understand that, of course.
Precisely.
This was a written brief
Right,
that
so
was...
you'll be identified as such. Now, you can verbally edit this as you go along and take it in your own way, but
No.
it's based directly upon your brief.
How much of this do you want in? Just the summary of the insurer's brief, or do you want to get into the argument portion
The
too?
argument and
Down to the conclusion?
the whole thing, yeah.
All right. Now, do you want to ask me any particular questions? Then
No,
I'll
you
get
can
into it.
just summarize your brief.
There's just one other thing. We had probably one other witness. Well, we omitted a couple, like Deneen, who merely, you didn't bring that out. Probably there was no need to. He was a professional photographer who took various
I'll take
films.
care of that.
All right.
I'll take care of that in the
Yeah.
interlocutory portion.
Fine. In essence, this concluded the insurer's case and the presentation of evidence in the case as a whole. At the end of these hearings, the single member, sitting as the commissioner, then suggested to both counsel that where this was not only a very serious case, but certainly a rather unusual one, that each file briefs in behalf of his client. This was done, and I would like to hit upon the highlights of the insurer's brief, which ultimately was filed with the commissioner. In a
Could you comment on what you're attempting to accomplish in these various stages of your brief? For example, when you comment on the facts, you're trying to highlight certain facts, bring them very sharply to his attention. I mean, this will be interesting, I think, to hear how the theory of the brief is developed.
Now, in developing a brief for the insurer, I felt it was incumbent upon me to highlight those facts which came out in evidence and which could not be argued as being presumptive or otherwise, but which were actually a matter of record at this point, and to stress on those which would bear out the insurer's contention that, taking all the facts into consideration, this was a case in which clearly the employee had stepped beyond the bounds of his usual everyday course of employment for Clarence Patton and performed an act which, according to law, was one which constituted serious and willful misconduct on his part, and therefore, still bearing out the insurer's contention, was an act which in and of itself was sufficient to warrant a dismissal of his claim before the Industrial Accident Board. Having that in mind, I attempted to stress in my brief for the insurer, one, the fact that this employee had been an iron worker for 4 years, and therefore certainly was well acquainted with his trade, the do's and the don'ts of his trade. That prior to the date of his injury, by his own admission, he had never ridden or been hoisted on the forks of a forklift truck. Further, that no evidence was elicited from any of the witnesses to these proceedings that construction workers had ever been seen to ride or be hoisted on such similar equipment. Furthermore, that there was uncontradicted testimony brought out by various experts such as Mr. Geisenheiner and Leslie Pratt that forklift trucks are in and of themselves materiel hoists or lifts and are not designed nor intended to serve as personnel carriers. The insurer further attempted to bring out in its summary of the facts in its brief that the lifting of the first tank involved no particular risk to the claimant, Vincent Asaro, that this tank raising occurred without any particular incident, and there was no evidence that it would have occurred differently had the second tank been raised by means of the same rope. Hence, that there was no evidence that the work which the claimant was called upon to perform on the morning of September 13, 1955, required by necessity, direction, or inference that he be hoisted on the fork of a forklift truck to a height of some 10 or 12 feet or more above the ground for the purpose of lifting the second tank onto the building. Further, that there was uncontradicted evidence that the act which led to the injury was prohibited by the Massachusetts Department of Labor and Industries, and further uncontradicted evidence that the operator of the forklift truck, Myron Castengay, had cautioned or warned Asaro of the dangers involved and explaining the reasons therefor. The insurer therefore argued that it followed logically that the employer in this case, Clarence Patton, could not reasonably have anticipated that such a hazardous and circuitous departure from the normal incidents of the employment would be contemplated, let alone deliberately pursued by one of his employees. Now, from the standpoint of the legal issue involved, which legal issue was this? Did the employee sustain a personal injury arising out of and in the course of his employment? Or, to put it differently, whether or not the employee was guilty of serious and willful misconduct. In its argument from the legal standpoint of the brief, the insurer contended that this was, in fact, an injury occurring as a result of an added hazard voluntarily assumed by the employee and which was not contemplated by his contract of employment. We cited certain Massachusetts Supreme Court opinions, the first of which was McNichol's case, found in 215 Massachusetts 497. In that case, in interpreting the phrase, quote, arising out of the employment, unquote, quote, the court said, an injury arises out of the employment when there is apparent to the rational mind, upon consideration of all the circumstances, a causal connection between the conditions under which the work is required to be performed and the resulting injury. Under this test, still quoting the court, if the injury can be seen to have followed as a natural incident of the work and to have been contemplated by a reasonable person familiar with the whole situation as a result of the exposure occasioned by the nature of the employment, but it excludes an injury which cannot fairly be traced to the employment as a contributing proximate cause, end of quote. The next case cited by the insurer was Hurley's case, 240 Mass. 355, wherein an employee was obliged to go from the blower room across an open yard to a forge. He went up onto a beam to get a raincoat which he needed, and then walked across the beam, using it as a footpath across the yard, holding on to another beam which ran alongside. He fell about 20 feet and was severely injured. The court said, quote, "It was not within the scope of the claimant's work to walk on the beam. Every circumstance demonstrates that the beam was not a place where his employment called him either directly or incidentally. He voluntarily encountered an added risk not within the contemplation of his contract of service. Even though he had to get on the beam for the raincoat, that was no warrant for using the beam as a footpath into regions where manifestly no employee was justified in trying to travel."
Or you can summarize these a little bit if you wish. I mean, it's up to you
Well.
how you want to handle them.
Then another case quoted was DeCosta's case found in 241 Mass 303, in which an employee climbed a ladder to see if gravel had got into a conductor at the edge of the roof. As he was about to return to the ground, he saw one of the painters apparently standing on the bottom rung of the ladder. So he chose instead to descend by means of a rope fastened beside the ladder, but placed there solely for use in erecting the staging. When he was 6 feet from the ground, he fell and was injured. The court said, "The sole question is whether this injury arose out of the employment. We think that the injury was not so caused and did not result from such a source as a natural consequence, because the rope was not designed nor intended for the use made." Then there are other cases, without going into the facts of each, which the insurer quoted in its brief. Amongst them, Eifler's case, 276 Mass, page 1, Boren's case, 227 Mass, 452, Koza's case, 236 Mass, 342, Jacobson's case, 248 Mass, 466, and Lazar's case, 293 Mass, 538. In conclusion of its brief, the insurer took this position: that the employee's premeditated act of deliberately seeking an admittedly perilous means of being raised onto the building, in spite of having been warned of the inherent danger and without any need for such action on his part, constituted the voluntary assumption of a hazard not contemplated by his contract of employment. Consequently, although the injury occurred in the course of his employment, it did not arise out of the employment. Therefore, it was respectfully suggested by the insurer that, as a matter of law, the employee had failed to satisfy the burden which was his, namely, of proving that he sustained a personal injury which also arose out of his employment.
Well, I think that does it very nicely, Tom. Is there anything else that you would like to say about this case, or comments about lessons concerning workmen's compensation practice, problems that we might somehow work in here? As, after all, you've been at this game for a long time. Is there anything about this case that highlights some aspect of workmen's compensation practice that might be of general interest?
Just that you wouldn't want to try a case like this every day of the week.
I was wondering about such problems as, do you have the experience commonly that the factual picture which emerges from your investigation, affidavits, other data that you've been able to collect, shifts on you in the course of testimony? This is one of the big risks that you run, and that one of the great problems in legal practice arises from the extraordinary impact of an altered statement of the facts with a different emphasis, a different significance. Is this a problem that is common to work? It's common to all legal practice, but I mean, is it especially a factor? The people supply the facts that they need to show that their injuries did arise out of, and so on.
Well, as you say, in effect, it's always a problem in any legal case, and certainly in any case that reaches the stage of litigation. And facts are all important, because you can't apply the law, you don't know how to apply the law until you have the facts clearly ironed out in front of you. And what the facts may be in a given case during the investigation of it certainly don't always resemble the facts that come out in evidence at the time of trial. Sometimes there's little or nothing you can do about it, because I've learned one thing in doing this work over a period of some years, and that is this, that what one or more investigators may take as the facts in a given case, in all sincerity and honesty, sometimes represent their opinions of what they understand the facts to be, and are not necessarily the facts which will ultimately come out during the course of a hearing or a trial, and I'm assuming always the honesty and integrity of the witnesses. So that's a factor to always contend with. And oftentimes I'll be trying a case, any one of us in this profession will be trying a case, either for the plaintiff or the defendant, the employee or the employer, and we will understand in given cases how things that we were led to believe were facts in a given situation probably were half fact and half opinion or conclusion, as we see them develop at the course of trial or hearing. And whether we like it or not, there's not always something we can do about it.
Would you give an illustration of something that's half a fact and half a conclusion?
Well, if I can think of a good application, I will.
Take in this case, for example, in connection with the rope or lifting the tanks or any aspect of this case, what kind of a statement would be? Would you classify as half fact and something?
I think I'd be hard put to give you an illustration based on the facts of this case, unless it be possibly some of the broad aspects having to do with the lifting of the first tank by means of the rope.
For example, when a fellow makes the statement, "This was dangerous."
Well, that's a conclusion, an opinion or a conclusion. And
could you restate that?
Well, let's say, for instance, and I believe there was some testimony to that effect by the Deschler who was pulling on the rope from the second floor level, that this was dangerous. Let's assume he said that. I don't believe he used the word "this was dangerous," but he implied that it was a rather difficult task in lifting the first tank that way. But let's suppose, for the sake of discussion, that he had also added, "Well, this was dangerous." First of all, that would be a conclusion on his part. It's up to the judge or the single member or a jury to determine whether or not it was dangerous. He can elicit, or rather he can describe what he has observed, what he has felt, what he has seen. Whether or not it was dangerous is for somebody else to decide, at least insofar as the claimant or the plaintiff is concerned. But that's always a situation that you have to face and that you're always confronted with. Allowing, if you tend to be asleep at the switch, a witness to describe something which he probably should not be allowed to describe, by putting in conclusions as well as facts that he has observed, conversations he has overheard, things that he has seen. That's probably one illustration.
Do you recall any discussion? Now, Mayu's case was mentioned in, it was item 7 here. In Mayu's case, 328 Mass, a recent case, the court stated that an injury does not arise out of the employment with results. This was a reassertion. And I don't know whether you and I have discussed this or not, but Larry has told me that this case was one of the real, posed one of the real problems, he thought, in litigating the Asaro case, because the added hazard doctrine, which had been slumbering for years in Massachusetts law, while it was not particularly germane, this was a horseplay case, the court took the occasion to reassert a principle of law, and Larry wondered whether the court was attempting to pour more new life into the added hazard theory. And I'm wondering whether or not you fellows, if you recall, whether you had discussed this and considered Mayu case to be an important case for you. We've got a couple of minutes.
Well, yes, to answer the question specifically, I did, and yet
could you identify it as you talked about?
In Mayu's case, 328 Mass 592, a fairly recent case going back now some 6, 7 years probably. The court did reassert what I suppose is a repetition of the doctrine of added hazard when they said in their opinion, and I quote, "An injury does not arise out of the employment when it results from the assumption of a risk not incidental to or connected with such employment," unquote. I made sure that I threw it into my brief for what it was worth, but the facts there were so different from the facts in the Asaro case, in that in Malou's case, there was the added feature of horseplay, so that the court just stresses that rule of law, which I assume is a repetition of the added hazard theory or doctrine, without going into it beyond that, so that
I thought that's a repetition of that rule of law, and quoting Malou's case, that didn't give me much to go on down there, so in quoting it, and of course indicating that this is a very recent case, at the time of the Farrell case, it was my intention to point out the fact that this is a law that isn't dead.
I think that does it for us, Tom.
Well, this session went a lot faster once we got rolling.
Sure it is.